I was listening to Scott Smith when I was still in law school, and so this is a really cool experience. And so last week we talked about kind of just really the overview of deal structuring, of compliance issues with the SEC when you're raising capital from investors. And today, and I kind of want to move through quickly because we've got a lot to cover, but today I want to go through what it looks like on a real estate deal. Some of the questions that you might need to, your attorney might need to know, and what I would need to know if we're structuring your deal, preparing your documents, and representing you on your deal. So as Liz mentioned, about maybe almost 2 years ago now, I guess, I was in a position where I was doing hundreds of deals, almost a deal a day, and a lot of these deals ended up, especially in real estate, after getting experience, looking at hundreds of deals, different deal structures, different deal types. I started putting together just kind of a system to where we can efficiently produce documents that, if it looked like the same kind of deal structure, of course we'd still have to customize it, make it specific to your the specific deal, but the overall deal structure could have the same provisions, the same wording, everything else like that. And so I started putting together this system, and now I'm kind of hopefully at the tail end of that. I'm still developing, still working with other attorneys to build it out, to just to provide more value to my clients. But so today I wanted to go through one of the questionnaires that I provide to my clients. If you came to me and said, hey, we got a real estate deal, we're looking to raise capital in 2 to 3 months, I would send you this questionnaire, and you'd fill it out. I wanted to walk through that today because it has a lot of valuable information, and I think will help structure our understanding of how to structure a deal and what information you would need to know. So, okay, so when you go in, you'll first start off with the contact information. So this is what you'll initially see. And then, because I've already filled it out, anytime I hit continue, it's just going to go back to the end. But typically, if you're filling this out, it'll take you to the next section. So you'll fill out those questions. But in this case, because I've already filled it out, it'll just take us to the end of the questionnaire. So it'll look like this, but it'll be helpful because we can move through it faster. So the first questions we have is what the deal structure is. And so last week we talked about several different ways to structure a deal. Obviously we have identified deals, we have blind pool funds, we have fund of funds or feeder funds, however you want to say that. So we start off, my first question is, what's your deal structure? Are you doing an identified deal? Are you going to be doing a non-specified or semi-specified fund? A semi-specified fund is one where you maybe have a deal identified, but you want to continue purchasing more assets, that you maybe haven't identified. So that would be what we call a semi-specified fund. And then, if somebody just wants to raise their hand, and we'll go through this, and just kind of go through, because there's more options here. So if we say no, this won't be a semi-specified fund, another question will pop up and ask, is this a feeder fund? Last week we talked about a feeder fund. How I typically use feeder funds is if there's somebody who has good capital connections, but they don't necessarily want to manage the actual property. We might structure it like a feeder fund in order to avoid violating the Securities and Exchange Act. So this question, this question will pop up. So we'll go ahead and say that this is a fund. And we'll say it's not an opportunity zone. But if it is in an opportunity zone, there's different ways we can structure that. And I don't want to make this an opportunity zone lecture. There's a guy on here, Patrick Shagru, who would be much better at this than I would. But there are different ways to structure the opportunity zone. And so if you are planning on doing that, we can talk through that at some other time. So we're going to say that this is a fund. So we're going to be structuring a fund, which basically one of the nice things about a fund, and it's not right for everybody, but the nice thing about a fund is that you can always, you have more flexibility. So instead of finding a deal, rushing to get the capital, rushing to close it, a fund, you can usually start raising capital over a period of time. And as you find assets, you can then start purchasing those assets without worrying about where the money is going to come from, if you can close on time, etc. So the issuers, so the next set of questions is the issuer's information. The issuer is the company that is going to be raising capital, and why it's called the issuer is because they're issuing securities. And so when I ask what's the issuer's information, think of the company that is going to be issuing the shares, raising capital from investors, and they're gonna they're gonna issue the securities. Now I have some information in here that explains what the issuer is and how I typically set it up. And I showed this in a graph last week, but how I typically set it up is we have the issuing company, and it's usually set up as a manager managed company. And then we have a management entity. And then within the management entity manages the issuing company. And then underneath the management company, we have Class A members and Class B members. Class A members are the investors. Class B members are the sponsors. And the reason why I separate those out, I don't know if I talked about this last time, but the reason why we have these different class members is because the investors are going to get let's assume that it's a 70-30 split. The investors are going to get that 70-30 split, or that 70% of all distributions. The sponsors are going to get the 30% of distributions. I didn't go too much in depth, I don't think, last week, but typically the Class B members, I like to have them hold their Class B shares in a separate entity from the management entity. And the reason why is because it just separates out the liability between the management entity that's going to be doing all the work and kind of accepting all the liability, and the Class B shares, which takes the promote, right, or earns the promote, and that promote is that 30%, and that's going to be the bulk of your of the income, or the value that you receive in a deal. And so you want to, so again, the way I set it structured is I separate those two. Excuse me. And so the issuer's information, I just put Syndication Capital Fund here. I said it's a Delaware entity. And you can also select whether it's an LLC or a limited partnership. In most cases, especially in real estate deals, I prefer it being set up in an LLC. There might be some consideration as to why you set up a limited partnership. But typically the limited partnerships I usually see only in specific deals like oil and gas, or specific asset type deals like oil and gas. Sometimes if I'm working with a foreign investor who's coming in and doing a syndication, sometimes they prefer a limited partnership because, for example, I don't think Canada recognizes the LLC, but for the most part, it's almost always going to be an LLC. But just know that that's an option here, is that you can select that it's a limited partnership. Then we'll go to the management entity. And we already talked about how the manager is the one who manages everything, and they take care of they're the ones who run the day-to-day. Within the management entity, the members of that management entity, and I always recommend that the management entity be an LLC, not an individual. And the reason why is because, again, that management entity is going to be doing, or the manager is going to be doing all the work on that deal. And so when they, so they're probably going to be the one who accepts the most liability for the LLC. Now, in my documents, I provide for indemnification of the manager. So in other words, if the manager accidentally, messes up or does something wrong that gets the company in trouble or something, if somebody sues the manager, the company, the issuer, will indemnify the manager. But nonetheless, we still want that management entity to be an LLC or some sort of entity that protects the individual from individual liability. So that's how we set that up. Here again, I just call it Syndication Capital. It's formed in Delaware. Now, one thing that we also want to do is, again, in my documents, I provide for arbitration. What I say is, hey, if there's any disputes between investors and yourself, or between the company or the manager, we don't want to just rush to litigation, right? We want to kind of, we want to take some steps to mitigate the risk of litigation. And so the first step is arbitration. Actually, it's mediation and then arbitration. And but if you're going to do arbitration, we say, hey, you got to pick a city and state to do arbitration in. And usually it's the city or state that the manager or the majority of the members of the manager are in. So in this case, I'm just going to say Jackson, Wyoming. The next part of, and this is all related to the management. The next part is the sponsor's information. So we're just going to say that so basically we want, in this management entity, who are the members of this manager, right? That's usually the sponsors. or that's defined as a sponsor. And so who are the sponsors? Who are the ones who are going to be controlling the deal? And the reason why we want to know not only their names, but also the percentage information. And I believe Seth Bradley spoke about this on his talk. But essentially, it is the SEC has guidance for what information needs to be disclosed, and they do state specifically that they want to know not only who's going to be controlling the deal, how much control do they have, which is why we ask for the percentage, but they also want to know the bio. Excuse me. And I used to ask for clients to fill out the bio in here, but it tended to just be kind of a daunting process, and so now we work with it outside of the system, but we do need the sponsor's bio as per SEC guidance. So in here, I'm saying, okay, Steven Slawinski, I own 50%, and then John Doe, my partner, also owns 50%. And for most of these things, you don't have to put the actual percentage sign, just kind of the way the system works. You just have to put the number. And then here's I am going to jump into this because we're going to go to the fee section. Okay, here we go. So typically, if you're going through this from the beginning, you would see an instruction page right before you get to this page, and it would give you all the typical fees that you might see in a real estate deal. You can have whatever fees that you want. You can come up. I've seen all kinds of fees. But the most basic ones are the acquisition fee, the asset management fee. If you're doing either a heavy value add, or if you're doing a development deal, you might see a construction management fee or developer fee. Actually, construction fee and developer fee might be two separate things. But these are all things that you can charge. And last week I showed underwriting model that kind of went through a lot of the fees, and you could see how those fees can really add value, could really add some income to your deal or income to the management entity. And that's also a good point. So the fees typically go to the management entity, right? Because we said that the promote, that 30%, goes to the Class B members, which are still the sponsors, but we want the sponsors to be different than the management entity. So, but the management entity gets the fees. And so there are all kinds of fees that you can charge. And of course, if you want to, if you want to ask about what fee, what kind of fees, what the market, what the market is charging, just, feel free to ask. But in this case, I set up the fees to be the acquisition fee, which is going to get paid to the manager. And it's going to be 2% of the purchase price of each property. And we want to know when the fee will be paid, and we're going to say at the closing of each property. Now, remember, this is a fund, so you're going to get an acquisition fee or you can get an acquisition fee for every property. So we want to specify that it's not just a property. So for example, in a syndication, we might change this to at the closing of the property. And in this case, we're going to say it's for each property that you purchase. And those little words matter, right? I mean, it seems like such a small thing, but to say, go from the to each, and I don't want to get too deep into legal theory around contract construction, but that it's a very important distinction here, right? So it's going to be 2% of the purchase price of each property at the closing of each property. And in here, I went through other fees that I won't go through all of it, but as you can see, we've got the asset management fee, a refinance fee, a disposition fee, and a property management fee. Now, the property management fee, the reason why I have it in here is because in my scenario, I am saying that I'm going to be managing the properties, maybe through an affiliate entity, another entity that I own, but I am going to collect the property management fee. So if you're planning on outsourcing that, you don't have to put that in here. But for the sake of example, I'm going to put that I am going to collect a property management fee, and it's going to be 4% of gross revenues. And so we talked about this last week about we touched a little bit on the pros and cons of 506B versus 506C. And again, the main thing is that with 506B, you can take up to 35 non-accredited investors, but you can't advertise. And there are, I mean, I can spend a long time just talking about the advertising aspect of like what constitutes advertising, what doesn't. There's a lot to do with social media. What if I'm in the middle of a deal, can I post on social media just about my company, about who I am, what I do, etc. I mean, we can get into the weeds with that, and it's so deal specific too that oftentimes it, sometimes just requires a conversation with me before you post something. But so that's the benefit of 506B. 506C, the great thing is you can advertise. You don't have to worry about that. The downside is that you can only accept accredited investors, which is fine because most deals close because of accredited investors. But you also have to take steps to verify that they're accredited investors. And this has actually become very easy over the years, because there's several companies that provide verification services for, pretty inexpensively. And the nice thing is that the SEC has said that, and this is a somewhat recent development, that once they're verified, once, that verification is good for up to 5 years. So that's kind of the benefit of a 506C. Now, I also talked about last week how the SEC very recently basically proposed or adopted a new rule, which basically says you can do a 506B and a 506C on the same deal. And I mean, you can imagine the benefit of this is that if you had friends and family that maybe didn't qualify as accredited investors, but you also needed to advertise or generally solicit, for example, making cold calls, hitting people up on LinkedIn, things of that nature, you needed both in order to close your deal. Now you can do it. You used to not be able to do it. You used to have to, the SEC basically had this laundry list that said, hey, if you're raising capital for something that's going to be in the same, for the same project or the same financing scheme, then you can't go from a 506B to a 506C. But now they're saying you can, which is really awesome. There are some specific things that you have to do in order to comply with that, in order to rely on that exemption. I call it the integration exemption. But again, we can talk about that if you are wanting to do this. But I give it as an option in the questionnaire. And so the minimum and maximum offering amounts, I explain the difference between a minimum offering amount. And by the way, if I'm going too fast, please just please stop me. Since I'm sharing my screen, I don't want to click into a chat in case there's anything personal there. But if you guys could just raise your hand on the screen, I'll see it, and I will go ahead and slow down or answer any questions while we're going through this. But the minimum offering amount, not everything is not every deal needs a minimum offering amount. But let's say that you want to, well, let me kind of back up and explain what this is. I have it here, but the minimum offering amount is the very minimum that you need in order to make a deal work, as opposed to the maximum offering, which is just what you would like to have on a deal. So I'll give you a couple examples on an identified deal where you already have a property identified, you already have the underwriting, and you know how much you need to make that deal work. You may not need a minimum offering. You may just have a maximum offering, and you still might want to buffer that maximum offering with a few $100,000 or a couple $100,000 or something in case something changes or a contingency comes up that you need that additional money for. But let's say you're doing a development deal, and you have multiple phases. This might be one example where you say, hey, at least to get to phase 2, we need we need at least $1 million, right? And if we don't hit $1 million, then we know that we can't get this off the ground. But if we do hit $1 million, we can get through at least phase 2. And if we have to sell it at that point, at least we can sell it at a profit, right? But so we need at least $1 million, but we need we need $3 to $5 million. Let's say $3 million to make the deal work. And so that would be the maximum amount. You often see this, or I often see this on funds. The minimum offering amount occurs with funds, or even heavy value add projects where you're saying, hey, we want to put in a lot of work into this apartment. So we need at least this much, but we want to raise at least this much. I personally like having a minimum and maximum, just because it gives me a nice buffer, in the deal. So in this case, I did say we are going to have a minimum amount. And by the way, it's important to say, and this is kind of a legal, in the weeds kind of a thing, but it is important to know that this is what's considered a best efforts offering. Um, there are several different kinds of types of offerings, including an all or nothing, or I forgot the exact term. It's some or nothing. But essentially, when you're working with broker dealers, if you're going to bring in a broker dealer, they have specific requirements. For example, if you say, hey, this is an all or nothing deal, what you're saying is we either raise all of it, or we raise all of it, or if we can't raise all of it, then we give all the money back, right? And so that money stays in a segregated account. It has to stay in a segregated account before you can break in impounds. But we always set up, at least for most, I shouldn't say we always. So anyways, this is a best efforts offering, so that if you raise a certain amount, you can still deploy capital. You don't have to give investors their money back. However, and this will go down to a couple other questions. First, what is the minimum offering amount? Again, because this is a fund, I'm going to say it's $1 million. And this is where I was getting to. If you are planning on deploying capital, in other words, if you aren't going to keep the money in a segregated account, we want to disclose that. We want to make sure investors know that, hey, I will be deploying capital. But if you are planning on deploying capital prior to the minimum amount being raised, or even the maximum amount being raised, for example, if you just want a maximum amount raised, you still want to let investors know that you do plan on deploying capital prior to that amount being raised. Because if you aren't able to raise enough to meet your business objectives, then you will have to give investors their money back. However, if you've already deployed it, for example, if you use it to reimburse attorney fees or accounting fees or anything like that, then investors have to know that they may not get the full amount of their money back, or they have to wait longer while you liquidate the company and sell the assets in order to get their money back. Right. That's really important to know in a deal, and that's something that not everybody thinks through when they're just trying to raise capital, right? And they've got this business plan, they take capital, they deploy it, but if they run into an issue, what are you going to do? So we have to disclose those what could happen in that case. So do you want to deploy capital prior to raising the minimum offering amount? I'm going to say no, but you could also say yes. And if you say yes, and this is specific to purchasing assets, I do ask, are you planning on purchasing any assets with the funds if you deploy it before you raise the minimum amount? Because again, the minimum amount especially is the amount that you need to meet your objectives. So are you going to deploy that, right, before you have enough to know whether you're going to actually meet your business objectives? And if you say yes, then again, we have to make certain disclosures in the PPM, letting people know, hey, if we don't raise this amount, we might have to liquidate the assets we do purchase in order to get your money back. I'm going to say no for now, though, just for sake of this example. And then we also, you don't always, well, it depends on the type of deal. There are several things like an evergreen fund where you don't need a deadline. But let's say that you're raising a fund and you need to raise at least $1 million. Typically, we want to give a date as to when we want to raise that minimum amount by. Excuse me. So we want to give a date. And the reason why is because we want to say, hey, if we are not able to accomplish our goals, we don't just want your money sitting in an account not working for you. So we're gonna give it back by at least this date. So, and then finally, we got the minimum investment. What is the minimum that investors are required to make in order to become a member of the company? We're going to say 50,000 right here, but you can make that whatever. I do really recommend you make it higher. I have worked on deals where the minimum investment was $5,000. I haven't really seen anything less than $5,000, but I would recommend doing as high as you can, because the last thing you want to do is deal with dozens of investors with little pieces here and there. The more the better. But also it just depends on your investors and what they can afford. And so do you want to require investors to contribute only a portion of their capital they commit? So this question, this is kind of an interesting one because it, when I first started working on funds, this was a lot more popular. Now, and we're going to go to another section later that we call truing up mechanics or true up mechanics. But a lot of times people were worried about having their funds, and actually this is still the case. If you're doing a fund, let's say an investor commits $100,000, they may not want $100,000 just sitting there before you can find an asset. And also, if you're charging a preferred return, which we'll talk about in the next section, if you're charging a preferred return, you may not want all $100,000 to accrue. Or excuse me, you may not want the preferred return to begin to accrue while their money is just sitting there doing nothing. So what you could do is, instead of saying, hey, give me all $100,000, investor, what you can say is, hey, investor, give me 10, 20%. And if later you want, and when we find a property, then we're going to call your capital. We're going to call the rest of the remaining of your capital, right? And then if you don't give us your capital, then there's going to be penalties because you already committed it. We already trusted you. We went forward with our business plan, believing you. But now, again, if you don't commit your capital, or if you don't give us your capital when we call it, then we're going to levy penalties on you. So you can always say, if that's what you want to do, you can say yes, and then the question will be, what percentage do you want? And we'll just say 10%. Again, this isn't as popular as it used to be. Most people are, either take the full amount or they don't start raising until they find at least a couple properties. At least that's been what I've been seeing, at least as far as this year goes. That's been kind of popular. So this used to be really, doing capital calls used to be really popular. Now people see it as just a difficult administrative burden. So I'm just seeing it less and less, but that is an option. Then do you want to have different investor classes? And what this means is, essentially, let's say that you have a couple big investors who want to invest $1 million. Everybody else is going to invest $50,000, $60,000 or whatever they're going to do. But you want to give those bigger investors different voting rights, maybe different economic benefits, things of that nature. And so you can have different classes, right? And really, it doesn't just have to be voting and economic benefits that can be different. I've seen some where, for example, that there was one fund that was doing short-term rentals, and they said, hey, if you're a Class A1 investor and you give us, 100,000, 200,000, we're going to give you, a free couple nights at the Airbnbs that we purchase, right? So you can always do just kind of fun things like that to incentivize investors to pay more or to invest more. So in this case, we're going to say, yeah, we've got 3 different investor classes. Now, typically, and this isn't always the case, you can always base what makes a Class A member, a Class A1 member versus A2. You can always change that up, but typically it is based off of the investment amount. And so I ask down here, what's the minimum to become a Class A1 member? And just so you know how this is structured, typically the more you invest, the higher that's the priority of number, right? So if you're Class A1, that typically means that you've invested more or you have a higher priority than investor 2, then investor 3, etc. So in this case, how I have this set up is that a Class A1 member has to invest at least $150,000 to become a Class A1 member. Class A2 has to invest $100,000, and Class A3 has to invest $50,000. Now, remember, this is the minimum that we had already stated up here. And it seems redundant, but sometimes, but the reason why I ask it kind of twice is because sometimes if you say no, we don't have an investor class, then this is the only amount that we're going to base our documents off of. So yeah, so we still want the minimum investment for Class A3. All right, so the business plan, and this part's always fun. So we're going to ask what kind of investments will we excuse me, got tongue tied. Will we be investing multiple assets? And in this case, because it's a fund, we're going to say yes. Again, if it's an identified deal where we're buying just one, then we're going to say, obviously no. But in this case, we are going to buy multiple assets. And the cool thing is too, we can we can select all the other, as many as we want here, right? Or as many as we are actually going to invest in. Now, ideally, it wouldn't be all of these, because it would be really difficult, I think, to do, a multifamily deal, a mobile home deal, and a real estate development deal, because they all are different. They all have different risk parameters. So investors might be, kind of maybe the hungrier, less risk averse investors want real estate development deals, whereas the people who want to rely more on steady income might want mobile homes. So so theoretically, in a fund, you would probably only have a couple asset types, and it would be geared towards the type of investors that you're going to be bringing on. Are they wanting more income? Are they wanting more appreciation? And that's how you're going to decide what assets to invest in. Or again, I mean, if you're already in the market, if you're already taking down deals, then it'll be just based off of the actual deals that you do. Now, I am still adding to this. For example, you don't see industrial here. I am working on, I'm working with a company that's doing an industrial fund now. So, once I add those to my to this system, we'll add that. But we're constantly updating this. But right now, this is what we've got here. So I'm just going to say we'll do multifamily and self-storage. And then, because this is a fund, and I'm not going to go all the way back to the beginning, but because this is a fund, if we had answered that this was an identified deal, some of these questions would be different. But in a fund, typically you have investment periods, you have holding periods, and then you have a wind up period. And the investment period is as it sounds. It's the number of years you're going to take to invest all your capital. And so typically this is between 1 to 2 years. But if you're going to be raising capital for an extended period of time, maybe you have a bigger fund that you're going to, it's going to take more time to deploy that capital. It could take more. So in this case, we're going to say the investment period is 2 to 4 years. The holding period is 5 to 7. Now, I have default information for the wind up period, because it's, if you're going to be winding up the fund, you're probably going to want to wind it up as quickly as possible. And so that typically takes about 2 years, depending on how big the fund is, depending on how many assets, it could take anywhere from a year to 2 years. But we can always extend that out. I don't ask that question here because it's sort of a general sort of rule of thumb that it takes about 1 to 2 years. But again, we can always extend it out if we need to. So the next questions are about the specific deal criteria. If this was an identified deal, or if this was a feeder fund, we would ask we would ask this specific question a different way. But because this is a fund, what we want to know and what you want to tell your investors is, hey, here's our deal criteria. We're going to stick to this mandate, and you can step outside that mandate, but not too far, right? So for example, if you say, hey, we're going to be investing in value add multifamily, or we're going to be doing, investing in cash flowing self-storage, then that should really be your mandate. But if you say, hey, we got this great mobile home that we found, came across our desk, and we want to purchase it, maybe talk to your investors. You probably want to do some sort of notice to the investors that, hey, this is outside our mandate, but it's still within our risk parameter. It's still within, basically you told us that you wanted, cash flowing income, or cash flowing, you wanted us to purchase cash flowing assets. This is cash flowing, et cetera, et cetera. So, you can do that. All right. But again, I would really recommend sending a notice to investors that you're stepping outside that mandate. But we want to tell investors what that mandate is. So we want to know your specific deal criteria. And this is extremely important. Where are you going to be investing? How are you going to, what type of assets? Your investment strategy. Is it going to be value add apartments? Is it going to be, developing mixed use? What's the investment strategy? And why do you, and then your investment thesis, why do you think that that's a good idea? And so you can type it out here, or if you have it drafted up on a Word document, which, I recommend that before you start a fund specifically, you do have these kind of things already hashed out with you and your partners, and ideally also with some of your investors as well. See what they want and see how they, what would look good to them. But so if you already have that drafted up, you can also just drop it in a file here, and I'll get that. And then, of course, I ask if you'll be hiring a property manager, and I'll be adding to this. For example, if you're going to be doing construction, you'll also, we'll add, are you going to be the construction manager? Are you going to be the developer? Things like that, because the SEC in their guidance requires that any major contract that you have between the company and yourself as the sponsor or an affiliate, even if it's not the management company, you need to disclose that. Typically, in most of these deals, the most likely scenario is that if you have one of these major contracts, it's going to come as a property manager or a developer or a construction manager. And so we want to disclose that. Here, I just ask about the property manager, and if you're not, so I ask if it's owned and or operated by one of the sponsors. If it's not, you don't, in my opinion, and some people just go ahead and disclose it anyways. Certainly not wrong to do that, but SEC's guidance does not require that you disclose the property, or disclose every non-affiliated contract, but certainly doesn't hurt to do so. But in this case, I'm just going to say no. And you see that I don't ask who the property manager is. But if you are going to be managing the property, then I do ask for the specific name, because we need to disclose who the property management fee is going to go to. So that is the business plan. And finally, not finally, but the most exciting part, we got two more sections. But the most exciting part for me, probably for most people, is the distributions. So because we said that there are multiple investors, this page pops up. If we said there wasn't going to be multiple investors, it would have a different page would show up. But this is where, and we'll talk about the specific terms here. So I'm asking, the first question is, will you have a preferred return? Preferred return we talked about last week, and some of you guys might already know this, but it's not an interest rate, but you can think of it as sort of an interest rate. Investor, if you give me $100,000, then I will give you the first 7%. I'll give you the first of all distributions until you hit a 7% return on that $100,000. That's typically a preferred return. Now, it's not an interest rate, because if you don't have the cash available to make that, to pay that 7% or whatever that percentage ends up being, then it's not owed to the investor, right? As opposed to, say, an interest rate, where if you don't pay that interest rate, then they have recourse. They could foreclose on the property or something like that. So it's not quite an interest rate, but I think that's the best way to think of it. So the first question, but there's several parts of this preferred return that we need to think about. First, is it going to be based off unrecovered capital contributions, or is it going to be based off initial capital contributions? What that means is, let's say that if you say, hey, I'm basing it off initial capital contributions right here, that means if I invested $100,000, then I am entitled to 7% of $100,000, no matter how much the amount of other distributions that I get. Whereas if it's based on unrecovered capital contributions, let's say that we have a capital event where we refinance a deal, and I use those capital proceeds to pay the investor back, say $50,000 of their $100,000 initial investment. If I say the preferred return is based off the unrecovered capital contributions, what I'm saying is that that I'm going to pay you only 7% of $50,000, not 7% of $100,000 if it's unrecovered. But if I have a capital event, we get refinance proceeds, I pay you $50,000, and so your capital account is reduced by $50,000. But I'm still paying on the initial capital contributions, then I still have to pay you 7% of 100%. 7% of $100,000. So that's important. That's really important to know how what the pref is based off of. The other thing is it compounding or non-compounding? Again, is it simple? And essentially, you can think of it as a simple interest versus compounding interest. I would say that the most common is non-compounding. I've personally never worked. I don't think I've ever worked on a deal, and I've done hundreds of these. I've never worked on a deal where it was compounding. However, last week I told you about a website where I learned how to underwrite deals, and their model initially was for compounding interest. I thought that was interesting, but and I had to reorganize it to where I made the pref non-compounding. The other question is it cumulative or non-cumulative? In other words, if I'm not able to make the payment, if I'm not able to pay you 7% pref on your $100,000 in year one, does that, whatever that deficiency is, does that carry over to the second year? So let's say I paid 0% on that $100,000. Do I now owe 14% in the second year, or do I just owe 7%? If it's cumulative, then I owe 14%. If it's non-cumulative, then I only owe 7%. And again, because this is a multi-investor class investment, you're going to have multiple investors. My next question is, well, do you want to give different investors different preferred returns? And in this case, I said yes, just because I want to show the complexity of how complex these can get. And so each investor is going to get a different preferred return. And there's a couple ways you could structure this. The default way is that the class A1 gets the priority pref, and then it goes down to A2 and to A3. There's also a way that you can structure it to where everybody gets a sort of any available cash flow will go into separate buckets, and one will get paid, and basically all the prefs will get paid simultaneously from those buckets. But the default is that class A1 gets paid first, their pref first, class A2, and then class A3. And then I ask, if you are doing a class A1, what's their pref? Class A2, what's their pref? Class A3, what's their pref? And so I've just got here 9, 8, and 7. And then will you be splitting distributions above the PR, above the preferred return with investors? I answered here yes. And if that's the case, if we said no, then that would be it. But if that's the case, the next question I want to know is, are you going to treat cash flow during operations as a return of investors' capital or a return on investment? Again, I don't, you could talk to a CPA as to whether this is really a huge difference, because ultimately the investors are going to get the same amount no matter what, but it does matter as far as how their capital is going to get treated from a tax perspective. And so if you're going to say, hey, during operations, we're going to give investors, we're going to make distributions of operating cash flow. And by the way, I say it here, but we distinguish between cash flow during operations and proceeds during a capital event. So during a refinance or a sale of the property, or even during an insurance claim, those would be capital proceeds. But during operations, we say, hey, we're going to give this cash flow from operations to investors. How is that? Is that going to be a return of their capital or on their investment? Almost always it's going to be a return on investment. However, I have seen, and it does happen, enough for me to have make this distinguishment. I have seen it where people want to treat it as a return of capital. And one of the arguments for that, not sure if I agree with it or not, but a lot of people say, well, if I can return investors' capital, if they can get the first $100,000, then, or let's say an investor brings in 100,000, if they can get their $100,000 paid off, then everything else after that is an infinite return. Again, I don't love that argument, because it turns out to be the same amount either way. It's all semantics, but that's why a lot of people like to say, hey, I want to return investors' capital first. Now, the problem with how we have it set up is that you're still going to split it, say 70-30, in the example that we used earlier, if it's a 70-30 split. So you as a sponsor are still going to get 30% of whatever distributions are available, which means, I don't often see it where investors get 100% of their capital returned first during operations. Obviously, during capital proceeds they do, but during operations, you don't typically see that, because otherwise you could be waiting 3, 4, 5 years as a sponsor before you see any of your promote, right? And so people typically don't say, hey, during operations, I'm going to pay 100% to investors before they get their capital back, and then I'm going to take the 70-30 split. You typically don't see that. I have seen it, but the investor, unfortunately, and he told me this afterwards, he's like, man, I'm not seeing any capital until we sell the property. So I typically don't recommend, during operations at least, paying back investors' capital, giving 100% of operating cash flow to investors first. I typically say, hey, if you want to treat this as a return of the investor's capital, then still do the 70-30 split. But that 70% that's going to investors is just going to be treated as a return on capital, or of capital, excuse me. So here we have that question. And so we're just going to say it's a return on investment. And then, will you be providing different investor classes with different splits? And there are two ways you can do this. In other words, you could just say, hey, different investors get a different pref, and that's it. And then everything else just gets split 70-30 to all investors. Or you could say, hey, investors are going to do, and of course we could say no here, and then it would just ask, what do investors get? What do sponsors get, et cetera. But here, there's two different ways. You can say either all the distributions go into separate buckets, Class A1 bucket, Class A2 bucket, Class A3 bucket, so the splits are simultaneous. Or you can say, hey, the first is going to go, or all the distributions are going to go to Class A1 until they hit a certain hurdle rate, and then the next set is going to go to the A2, then A3, and then whatever's left over is going to go to Class B. So there's those different ways of doing that. So here I basically break that down. I give you the different options. And by the way, this isn't all exclusive. It's pretty lengthy, but there's 1,000 ways that you can structure this. These are just the ones that I've come across, and these are like the ones 90% of my clients use. But you can always say, hey, I want it structured differently. And of course, we have an option down all the way down here where you can explain that option or how you want to structure it. But in this case, I'm going to say, hey, I want to give different priority to different classes. And so we have Class A1, Class A2, Class A3, who are all going to get different priorities. Of the split that Class A1 is going to get, they're going to get 70% of all cash flow. The other 30% is going to go to Class B, until the Class A1 members hit a 20%, until they hit 20%. And then we're going to ask 20% of what? It's usually an IRR or cash on cash or something, 20% of something. Once they hit that, then it's going to go to Class A2. It's going to be split 60-40 till they hit a 17% IRR. And then Class A3 is going to get 50-50. And then the rest is going to go to Class A3. Class A3, it's going to get split 50% to Class A3, 50% to sponsors till they hit a 15% IRR. And then here I say, well, what's the basis? It's typically IRR, but you can also use average annual return, cash on cash, or if you have some other metric that you want to hit, you can put that here. But in this case, I'm just going to say IRR, internal rate of return. And this is the last one. I appreciate you guys sticking with me. I know it can be so daunting in the weeds, but this is just so important when it comes to disclosures and understanding the deal and just telling investors how it's done. The true up provisions. So here, and I actually have a video. I'm not going to play this. I'm actually really, it's kind of nerdy of me, but I'm very proud of myself that I just shot this video yesterday, and I finally learned how to upload this video into the questionnaire. So for anybody who is interested, if you work with me, you'll see this video. I can also send it to you, Liz. I can probably send it to you so I don't take up more time going through it. But yeah, well, it basically talks about the timing of investors' capital, how to account for that. I do have it explained up here, but basically, let's say you have an investor one coming in January, right? And you start deploying capital in February, and then another investor comes in November, and you give distributions in December, right? Let's say both investor one and investor two both contribute $100,000, but should investor two get the same amount of distributions as investor one, because investor one has been, in the deal much longer, right? Investor two has only been in for one month. How do you account for that? There's typically two different ways. Either increase the share price so that so investor one is not diluted as much because investor two's money doesn't go as far. So increase the share price, or prorate the distributions. The difference is that one, increasing the share price is pretty straightforward. I mean, it's pretty easy to conceptualize. Whereas prorating distributions, you probably have to talk to your CPA. Again, I have a spreadsheet, and this video in here does explain everything on how to set that up. But yeah, I have talked to at least one CPA who was like, oh yeah, my system isn't set up for that. So now I have to go in and redo my system to have it set up for that. But prorating distributions, in my opinion, is the way to go. Again, I can send Liz this video, and you guys can watch it on another time. But again, a lot of bigger funds do increase share price based off something called net asset value, rather based on an increase of net asset value, which means that basically if in month one, your net asset value was $1 million, and then in month two, it was, 1.1 million, then you could say, okay, well, it increased by this percentage, therefore the share price is going to increase by that percentage. You can also arbitrarily, and this is probably the easiest way to do it, even beyond increasing share price based off NAV or your prorating distributions, the easiest way to increase share price is just applying an arbitrary increase, either by a specific dollar amount or a specific percentage. The problem with, and again, I give you an option to choose from all three of those. And it's not exclusive options. I've seen some very complicated ways of doing this, of creating true up mechanics. Some of them are even things that took me a long time to understand, but these are the most basic and the most popular ways I think I've seen it. But the increasing share price based off arbitrary, an arbitrary amount, has the risk of, even though it's a lot easier than both the other ones that I mentioned, it has the risk of unfairly diluting either investor one or investor two, because either investor two is paying too much for the shares, or they're paying too little and buying more shares than they would otherwise be able to if it was based off something like net asset value. So with all that said, in this case, because it's a fund, I'm anticipating that I'm going to be making investments for 2 to 4 years. I'm going to say, yes, I'm going to be getting investments for at least 2 years. Therefore, I do want to prorate distributions based on timing. So what I've done, and I actually talked to Liz right before this call, and I was like, man, I'm kind of nervous to share this because I've gotten feedback both from lawyers and from prospective clients that what I've done can potentially devalue the service that I provide. Because what I've done, and I'll just be quite frank with you guys, I've automated these documents so that every one of these questions affects my template documents in a certain way. And these aren't the kind of templates that you're just going to rip offline and fill in the blanks. I'm going to share the back end of this just to show you how complex this is, where certain words, certain phrases, everything changes based on how you answer. And then we're going to go through so this is kind of how the sausage is made. All right. So all of this, all the colors are basically different coding that I have put into the documents based off all hundreds of deals that I've done. It's taken thousands of iterations. I still take at least once a week to update this, to fix, to add stuff based off new information that comes out by the SEC or new research information that I go through. I'm constantly building this out. But as you can see, this is not one of those things where you can just, go online. I mean, especially this is the waterfall section right here. It's almost 4 pages long, has over 150 variables. This is one of those things where it's, it allows me to, based off of how you guys answer, what you guys want in your deal. These documents are able to be generated at a much faster rate, but also, and I think this is the important thing, at a much more accurate rate. I remember the last law firm I worked for, I came in at sort of a tail end where they had just onboarded a lot of new clients. And at the time they were just using paralegals to do a lot of their drafting, if I'm being honest. And I spent most of my days fixing the errors in those, because clients would come back and say, hey, you got this wrong, you got that wrong, hey, you missed this. And so I spent most of my time just fixing those errors. And then the rest of my 15-hour days was spent trying to take care of new clients and get new documents out. So this system, I believe, is a much better, and I'll actually I'll show you the last thing in here, which is the generated documents. Okay,
Yes.
so as you can see, we have the minimum offering amount. Without, we said it's going to be $1 million is the minimum, 10 million is the maximum, 50,000 is the minimum, and this is all based off of SEC. This is very closely, this aligns as closely as possible with SEC's guideline, and where you can look up the SEC's guideline is SEC Guide 5 is what most real estate PPMs are based off of. But all of these terms, all of this is based off of, right? We have the Class A1, Class A2, we have the Class A2 preferred return, we have the Class A3 preferred return. We have all of this, and then I'm just going to go through quickly and show you some of the things that are input into here based off the answers that we gave, right? We had the Class A1 required contributions, how many shares they need to purchase. That flows from the questions. We talk about the holding periods, the wind up period, all that stuff for the fund. And then I'm going to show you and then here's the fun part, right? Here's the distributions of cash flow. Right, Class A1 goes to Class A1 until they hit the 9%, Class A2 until they receive the 8% pref, Class A3 until they hit the 7%. Then it goes 70-30 until the 20% IRR is hit, 60% to Class A2 members until they, et cetera, et cetera. So this is extremely, this is one of the most advanced. I mean, maybe I'm bragging a little bit, but so we have proration, the proration of distributions with an example of how it works right here. Again, patting myself a little bit on the back here. I apologize if that comes off annoying, but this is one of the most advanced systems that I've, drafting systems that I've come across. This is not like LegalZoom or anything like that, where they have kind of general information. This is very specific to your deal. If you remember, Steven Stolinsky was 50% owner, John Doe 50% owner. Acquisition fees are all here. So that's so that's my system, and so it just provides for it just allows for us to reduce human error, and improve efficiencies and improve quality of product. I mean, I've gone through hundreds of PPMs comparing what I'm doing with what other attorneys are doing, and we are always doing, just improving based off what we're seeing out in the marketplace and what the SEC is requiring and things like that. So it's a higher quality product, faster turnaround time, lower human error rate. And I'm really excited to share it. I will say I still charge market rates for my services, and people, I have had pushback saying, well, it doesn't take you that long. But this is the part about value that I mentioned earlier, is that value should never be based on time. It should be based off of the product produced, or rather the value that the product inherently holds. And so this, in my opinion, is a very valuable product that most law firms don't have. And yeah, Leah, I see your comment. Yeah, expertise matters, right? I mean, it's all about anyways, I'll get off my soapbox. I can go on for a while, right? I mean, as real estate investors, we know that, if you have a space, if you have a real estate, a tenant is not paying you their rent based on how much time you have put into the property. They do it based off of the space that you provide, right? So anyways, that's what I would just like to share. I appreciate you guys sticking it out with me and hearing me out. Really appreciate it.